Therefore, your charge to the offense of receiving a bribe contrary to Section 61A as well with Section 18 of the Anti-Bribery Act number 47 of 2022. Particulars are on the 11th November 2025 within the Republic of Kenya being a public officer to lead the chairperson, board of directors at the Counterfeit Authority. You requested for financial advantage of Kenya shillings 5 million from the decision with intent that in consequence you will forbear arresting and charging the decision for purportedly trading in counterfeited motor vehicle spare parts. Is it true or not true?
Not true.
Count number 2. Receiving a bribe contrary to Section 61 as well with Section 18 of the Anti-Bribery Act number 47 of 2022. Particulars are on the 11th November 2025 within the Republic of Kenya being a public officer to lead the chairperson, board of directors, and Counterfeit Authority to request for financial advantage of Kenya shillings 1 million from the decision with intent that in consequence you will forbear arresting and charging the decision for purportedly trading in counterfeited motor vehicle spare parts. Is it true or not true?
Not true.
Count number 3. Receiving a bribe contrary to Section 61A as well with Section 18 of the within the Republic of Kenya being a public officer to lead the chairperson, BOB and the Counterfeit Authority. You requested for a financial advantage of Kenya shillings 300,000 from the decision with intent that in consequence you forbear arresting and charging the decision for purportedly trading in counterfeited motor vehicle spare parts. Is it true?
No.
Count number 4. Receiving a bribe contrary to Section 61A. On 11th November 2025, within the Republic of Kenya, being a public officer to lead the chairperson, board of directors, and the Counterfeit Authority, you received a financial advantage of Kenya shillings 144,500 shillings from the decision through Dorui Erastus Kaibis mobile phone number 0721-766-124 with intent that in consequence you forbear arresting and charging the decision for purportedly trading in counterfeited motor vehicle spare parts. Is it true or not true?
Not true.
Count number 5. Attacks Cap 59. On the 11th November 2025, within the Republic of Kenya, you acquired a sum of Kenya shillings 144,500 from the decision through Dorui Erastus Kaibis mobile phone numbers, going or having reason to believe that the said money formed part of was proceeds of crime to which money obtained through bribery. Is it true or not true?
Not true.
That to the extent of publicity, I don't know. This is something that I thought we ended. You are giving an order that he should not, and not only to him, even to his advocates. I don't know why. We all know the sub judice rule. This court does not need to make an order that on something that is already known. All of us know the sub judice rule will cancel our client. It does not need to come unless you are told that today morning he called a press conference outside here. Unless he called a press conference yesterday, then there will be some basis of issuing that. Right now, on what basis will you issue an order anticipating something that there is no basis of it? Again, it will just go towards trying to stifle his rights. And the next time if you issue that, you'll be told, let all these journalists go out. They also should not report. Lastly, on the issue of non-interference with witnesses, we give that undertaking. That at the point that these witnesses will be disclosed to us, none has been disclosed, and my colleague has said as much. It is outrightly clear, and our client will give that undertaking, will not interfere with any witnesses, and it is important that that is disclosed. so that we know, because without that, an order can be given and the witness is his wife who is sitting in court. How will he comply with that? So it is important that that disclosure is actually made, so that at that particular point we are able, but granted, it's automatic that part of the conditions, you don't interfere with witnesses. He's been a lawmaker, so he knows about that. They are the ones who make these laws. So to that particular extent, Your Honor, I would really pray that you find it in your heart, favor to grant him cash bail or bond option. At a point, the officers had indicated that they were contemplating a cash bail of 50,000 at the police station. We are not so certain. He's someone who, as a chairman, does not even earn a lot. This is a very big title with nothing. He just gets 10,000 once in a while in terms of sitting allowances. So he doesn't even have that money, as much as he has a very big title. So I would want the court to, in considering the amounts, to also take judicial notice of this particular fact. Lastly, Your Honor, we will request for all documentary evidence, statements, and any electronic evidence that they may have to be supplied to us in good time. This is a matter that we will want to deal with as soon as possible. It's a matter we want to deal with as soon as possible. We know the current political environment we are dealing with, so we understand why this matter is here. So the soonest those documents are brought, we will be able to take the earliest hearing dates, and our client will have his day in court. Thank you so much, Your Honor. With your very kind permission, if my colleagues, there's something I've left out, can mention maybe in just 2 minutes. Very kindly, Your Honor.
Your Honor, my name is Ongiti again. We want to humbly pray that you grant a reasonable cash bail to our client. As illuminated by my colleague, the charge sheet is quite sensational and probably serving a purpose that is not known in law. It doesn't make sense to accuse a man of receiving a bribe and then delve into particulars and accuse him of requesting. It sounds more of a political accusation. We do not know whether our client is politically wrong, having served as a member of parliament between 2017 and 2022. Your Honor, our client is a family man. He has a wife and children who solely depend on him. The prosecution has considered that they are not opposed to grant of bail. The sole purpose of bail is to secure attendance before this court. That is the consideration, whether our client will attend to the trial before you. While they do not raise any issues or compelling reasons that our client will not attend court, they purport to limit your discretion in grant of bail by dictating terms that our client should be able to deposit his passport in this court. They have not accused our client of being a flight risk, but to keep the theory of sensationalism, they are requesting this court to keep his passport for reasons that have not been disclosed. It is strike law that if they allege, which they have not, that our client is a flight risk, they should have gone ahead to provide evidence. They have also requested this court that the accused person, our client, and his legal team should not make any media commentary. How unjust can the prosecution be to try and curtail the media freedom? Because basically they are not curtailing our client or his legal team, but equally the media from reporting these events. On Friday, when our client was arrested, they published everywhere that he has been arrested. If it was not malice, why don't they want the people of Kenya to know the truth? Because this is a man who has served as a legislator. His name has been tainted in the media, and now they want to bar him from making any statement over his arrest. There was even a press release by the DPP on 17th November 2025. It's a statement on bribery allegations against Honorable Josephat Ksh6, the chairman and Counterfeit Authority. Because of the politics that surrounds the nature of these charges, it is the reason why they want to curtail this right of our client to give any commentary. We endeavor to advise our client that he will not delve into the merits of the case before this court. The prosecution fell short of requesting you to ask the media out of this courtroom. Your Honor, there are no compelling reasons that have been stated why the demands by the prosecution should be met by this court. The right to bail on bond is a right that is guaranteed in our Constitution. Equally, the judiciary has gone ahead and put forth the bail and bond policy guidelines. Those are the guidelines that guide this court in determining grant of bail. Admitting our client to bail is a discretionary power of this court. The terms and conditions should be set by this court. And where there are no compelling reasons, as this case before you, we humbly pray that you grant our client reasonable cash bail and our client undertakes to attend trial as and when the court sets the dates. As I conclude, Your Honor, this court sits to determine cash bail and bond on a charge sheet that if this court sits back and asks itself, what will a standard man in the streets reading these charges think about the prosecution of our client? That on one hand, you are accusing this honorable man of receiving a bribe of 5 million on the same day. However, when you are asked to explain, you say that he has requested for a bribe of 5 million. It looks like a movie where two people were trying to negotiate. And without prejudice, if, for instance, in the theory of the prosecution, this is a negotiation that begins with 5 million, 1 million, 300,000, then 144,000. How on earth do you charge a man over a negotiation, if at all it exists, and then go ahead and request this honorable court to give terms that are consummate to the charges that, to our opinion, are not charges that are sustainable. They are charges that are politically instigated just to frustrate our client. There's only one charge. If at all they want this court to look at the charges and what is consummate for a cash bail, there's only one charge where the particulars align, receiving, and in the particulars they talk about receiving through. That is 144,500 shillings. So if at all, and I know this is a court of justice, this is a court of record, if at all they wanted to persuade this court, then that is the amount that this court needs to consider to grant our client a reasonable cash bail. Your Honor, we humbly pray that this court has not been given any compelling reasons to give the dictatorial terms by the prosecution, and considering the charge sheet before you, we humbly pray that you grant our client reasonable cash bail to enable him prepare for his defense, and on the principle that our client is presumed innocent until otherwise is proven. We so pray, Your Honor.
There's a clear distinction between requesting and receiving of a bribe or a benefit. And that was the guiding principle in the framing of these charges. And in due course, during trial, we shall avail the necessary evidence to that effect. Therefore, it should not be mistaken that we should only charge for what has been received. You know, secondly, the law does not discriminate known or associated with. The law is equal to all and should be applicable equally to all who come before it. Thus, we should not give any special treatment to the accused person by virtue of being a former member of parliament. I will urge the court to have that in mind. Thirdly, Your Honor, the terms and conditions we've sought are to ensure proper administration and management of this case. And to safeguard the integrity of this trial. And this is in line with the sub judice rule, which my colleague has pointed out. We have not asked for this case to be barred from being covered. No one has done that. Our request was on the parties, the defense and ourselves, for making adverse comments or going down to the merits of this case publicly. The rest are allowed to do that, and we all know that. Therefore, the request was to safeguard the integrity of the trial, and is in that context that we sought for the prayer to bar the defense from making adverse comments in the media. So no freedoms are being curtailed. We are alive to the rights enshrined in the Constitution for all players, including the media who are before us. You know, lastly, we are ready to disclose the materials that are required for this case. You know, we kindly request for 2 weeks to make the necessary preparations for purposes of disclosure. And we'll be ready to take further directions as shall be rendered by this honorable court.
Council, and the submissions made by all the councils for and against the said application. And this court says that it is clear from the submissions made that the prosecution does not oppose the release of the accused person on bond or bail terms. It is also clear that there are no compelling reasons provided by the prosecution to warrant this court to deny the accused person the opportunity to be released on bond or bail pending the trial. And as regards the issue of the accused person having his passport deposited in court, it is my considered opinion that such measures are procedural in nature, and with regard to cases of this caliber, they are meant to safeguard the proper management of the case and to ensure that the court is able to secure the attendance of the accused person. The same does not pose any form of prejudice to the defense, since the documents shall always be released to the accused person should need arise for him to travel outside the country and away from the jurisdiction of the court. That also helps the court to supervise the terms of bond and bail, which require the accused person to attend court as required or as ordered by the court. On the issue of media coverage, this court is alive to the media coverage rules that have been set out by the Honorable Chief Justice. which shall be adhered to in this matter. What the court will not allow is the adverse media commentaries regarding this matter by any of the parties in the case. This court calls upon all the parties to adhere to and to uphold the sub judice principles imposed upon such a matter. Parties shall not be allowed to discuss the merits of this case outside the courtroom, as the matter is already sub judice. In that regard, this court finds the application made by the prosecution not to be punitive in any way, neither is it meant to curtail the constitutional rights and freedoms of the accused person. The orders sought by the prosecution, to me, are meant to provide proper administration and management of the trial, and also to safeguard the integrity of the suit. I do hereby allow the application and proceed to make orders as follows. Number 1, that the accused person shall be released on a bond of Kenya shillings 2 million with one surety of a similar amount, or cash bail of Kenya shillings 1 million. Number 2, that the prosecution shall provide and or supply all the witnesses, the witness statements and the documentary evidence intended to be used in this trial, together with any electronic information, evidence, and or devices intended to be produced as exhibits in this matter within 14 days from the date hereof. Number 3, that the accused person shall deposit his passport and travel documents in court within 40 days from the date hereof, pending hearing and determination of this matter. Number 4, that the accused person and all the parties shall be and are hereby barred from interfering with the witnesses in this matter. Number 5, that the parties are also barred from making any adverse or negative commentaries or social media coverages that are meant to derail the merits of this case, pending trial and determination. Number 6, that this matter is hereby allocated to court number 2 before Honorable Ondieki for trial and for further orders. Those are the orders of the court.